I just want to check if my sound is fine.
Good afternoon, Mr. Nehouse. Yes, it's clear. Thank you.
Okay, thank you. You're not very clear. I don't know what's wrong. Just speak again.
Is it still not clear?
Now it's clear. Thank you. It's fine.
Thank you.
I'll
All right.
rejoin closer to the time. Thanks.
All right. Thank you.
Good afternoon, honorable members.
Good afternoon, Honorable Chair.
Chairperson. Right,
Good
Chairperson.
afternoon.
Thank you, Chairperson.
Okay, thank you very much.
Good afternoon, Chair.
Good afternoon, Ndadembata.
Yebo ba.
Yebo, mhlonishwa.
Yeah.
Sorry, Chair, you are muted.
Recording in progress.
Okay, thank you very much, Nadipa. Good afternoon once more to all the members in the platform. Let me take this opportunity to welcome all the members, welcome the Parliamentary Legal Services, welcome the Department of Defense, the Legal Services, as well as the SecDef. Also welcome the member of the Executive, the Deputy Minister, Honorable Mukungo. Welcome the support staff from our Secretariat, and also welcome the support staff, liaison staff from the offices of the Executive. You are all more than welcome. I see also the members are present, parliamentary staff is present. You are all welcome. There's the agenda before all of us. We've dealt with the first item. The second item, it's apologies. The third item is feedback from the Department of Defense on legislative developments, progress related to the Constitutional Court ruling, including amended timelines where relevant. The fourth one will be the input from the Constitutional and Legal Services Office on the way forward regarding the legislative developments. Then we'll have consideration of minutes and closure. Can we get a mover and a seconder for adoption of the agenda?
I move, Chair.
Thank you very much, Honorable Niaus. Any seconder?
I'll second, Chair.
Thank you very much, Honorable Hatting. I'll then move to the next item. Nandipa, any apologies on your side?
Good afternoon, Chair. Good afternoon, members, and afternoon to the Deputy Minister and everyone in the platform. There's an apology from the Minister who she's traveling to China. And then there's an apology from Ms. Nontenja. She has other commitments. And Mr. Ala, he's attending a career exhibition of the Department of Education of the Eastern Cape and the SANDF. He's representing the committee there in that exhibition. That's all, Chair. Thank you.
Thank you very much. Those are the apologies. I don't think, because it's a continuation meeting from our last meeting of last week, Wednesday, we could not proceed yesterday because of the appropriation bill adoption we had to consider today. We know the apologies. Can we move to the next item, which will be a feedback from the DOD on the Concord ruling, including the amendment of possible timeframes, so that as the committee we can decide whether do we go the executive bill or do we go the committee bill. I'll now hand over to the department. I see today it's led by Honorable Deputy Minister. I'll hand over to the Deputy Minister to introduce the presenters. Over to you, Honorable Mukungo.
As you indicated earlier on, Chairperson, in that the state of readiness at the time had some challenges. We have since rectified our mistake. Timelines were completed. The staff is ready to present the item. Major General Mnesi, in this regard, will present this issue. General.
Over
Good
to
afternoon.
Okay.
Chair, have you seen my hand, Chair?
Your hand. Okay,
Yes, Chair.
Honorable House.
Chair, may I make a
Slide.
proposal that we first get the presentation from the parliamentary legal advisors, because they have particular advice on timeframes and the technical side, and then we get the presentation from the Department of Defense and Military Veterans, so that we can interpret their interpretation in the context of what the legal advisors are advising us to do. I think that would be a helpful way of going about it. Thank you, Chair.
Thank you, Honorable House, but we have already adopted the agenda. I would request and indulge on you that we proceed, allow the parliamentary legal services to take notes from the presentation of the department. If there are issues that the legal services needs to advise us on, they note it after while the department is presenting, so that once the legal services comes in, we know what needs to be corrected from the side of the department, so that we leave it at that in the way we have adopted it.
Okay, Chair, that's fine.
No, thank you very much. Let me then allow the Department of Defense, as per the instruction of the Deputy Minister, that Major General Mnisi proceed to the presentation from the department. Major General, we hope that will deal only mainly with timelines, because that was our issue in the last meeting. But the other point is that the bill, are we taking it the executive way, or are we taking it the committee way? Then you'll advise us. If you are ready as the department to proceed, tell us you have the capacity, so that we leave you to finalize the bill. That's what we're interested in, but I'm sure also the parliamentary legal services will come in. But I'll now hand over to Major General Mnisi. Over to you.
Thank you very much, Chair. Am I audible that side?
Very much, General.
Thank you very much, and good afternoon, Honorable Chair and honorable members of the PCD and military veterans, to our DM and also SecDef and Chief of Staff of the South African National Defence Force and my colleagues. Chair, as you instructed me that I must just go straight to the timelines. Indeed, Chair, again, I want to take this opportunity to thank you for allowing us to come back and present the revised timelines to the committee. Sir, as you will see that we have just done that, and you will see at serial number 1, the effecting of amendments to legislative, effecting of legislative amendments to both the Defence Act and the Military Discipline Supplementary Measures Act are done. Serial number 2, 3, and 4, we presented to the Plenary Staff Defence Council on the 21st. Then we also presented to the Minister on the 21st of July 2005. And then we also issued out invitation for comments on the same date. Sir, you will see that we given internal consultations or comments till the 1st of August. We already sent the same draft amendments to the Oxla in Cape Town, and we have received their confirmation of receipt of that. We have received that. So in August we plan to do our CLs. Also in August we want to take the draft bills to that DEFCON. That will clear it to be presented to the JCPS DGs cluster in August, September 2025. After that, we'll submit. Next slide. We'll submit it to cabinet subcommittee, to cabinet or cabinet subcommittee in September, October, and we to cabinet in September, October, so that by the time November, December, then the minister can definitely have an opportunity to table this thing to Parliament. So we had to squeeze everything to December, Chair, as we have been requested and instructed by your good your committee that everything must end in December. So we squeeze everything in December, and there will be things that will run concurrently, although even if they run concurrently without messing up with the legislative process. So in this, we want to confirm that yes, the department has the capacity to go with this, and we also want to confirm that we'll prefer the executive bill to the committee bill at this stage. We also confirm that at any stage when this August committee wants us to come and present ourselves, how far have we gone, we will be ready to update the committee. And if there are any challenges, we'll also be ready not to be asked by the committee, but to liaise through our command and control channels, that we must come and brief the committee on the challenges that we faced on the road. I submit, Chair.
Thank you very much, General. Is there any addition from the department? If there's no addition, we'll then move to the Parliamentary Legal Services. Any addition from the department? Okay. In the absence of any, we'll then move to the next agenda item, which is the item on the submission by the Parliamentary Legal Services. I'll now hand over to you, Parliamentary Legal Services. I'm sure you have heard the input of the department, including their new reviewed deadlines and timelines. If they are compatible with your parliamentary program, your parliamentary guidelines, and the rules of the National Assembly and the portfolio committees, you are welcome to advise. If there's anything that needs correction, you are also welcome to advise. Over to you, Parliamentary Legal Services.
Thank you, Honourable Chairperson. Yes, we've considered the new timelines. It's much improved. It does create a more realistic time frame. It alleviates the pressure then on the committee to meet the timeline set by the Constitutional Court. As we presented last week, Chair, the introduction of a bill in February would also have been possible, but that would, of course, have placed some pressure on the committee staff. Bearing in mind the new timeline from the department, I think it would still be valuable for the committee to hear or to consider the contents of our opinion, which we shared with the committee earlier this week. So, Chair, if you want me to go through that opinion, I will do so.
No problem, you're welcome.
Okay, may I share my screen, Chair?
Yes, permission granted.
I see the host has disabled me. I don't think I've been granted. Okay, I've been granted sharing rights. Okay, Chair, is the opinion... Can you see the opinion on the screen, Chair?
Yes, I can.
Okay, Chair, this legal opinion which we shared earlier this week is a supplementary. It's supplementary to the legal opinion which we presented last week on the 16th of July. Chair, you did request our office to prepare a legal opinion on what would be the best course to follow to remedy the constitutional defects in the impugned provisions of the MDSM Act and the Defence Act, and to ensure that Parliament complies with the timeframe set by the Constitutional Court in the O'Brien judgment. Chair, essentially, you required a legal opinion on whether proceeding with a committee bill or alternatively waiting for the department to table an executive bill will be the most rational legislative route to follow. Chair, as we discussed last week, in respect of processing a possible committee bill, the following factors will favor the development of a committee bill. If the bill is likely technical in nature, with little or no policy development required, if the court has provided a reading down that could be utilized in the committee bill, if a court has provided if the bill will deal with a non-contentious matter with little or no policy development required, or if the bill will only deal with issues and content affecting Parliament or provincial legislatures. And Chair, in accordance with the National Assembly rules, should the National Assembly grant permission to the committee to proceed with the committee bill, the committee will then proceed to develop a draft and may do so with the assistance of our office. Now, Chair, our office generally requires a period of 3 months to develop the first draft of a committee bill. However, considering that the Constitutional Court has provided reading down provisions, in this case, it would be an approximate period of 6 weeks to develop a first draft. However, as we discussed last week, the Constitutional Court did not provide a remedy for the constitutional defects found in Section 17 of the MDSM Act. So the department would have to develop policy to remedy that impugned provision. So, Chair, there are factors which would favor the development of a committee bill. However, in respect of Section 17 of the MDSM Act, the Minister must deal with the necessary policy development. So the department may then proceed to either bring an executive bill or provide our office with the necessary policy to be included in a committee bill. So it must be stressed that the department's role when a committee bill is being developed is vital, and it is in fact a requirement in terms of the rules. So we are of the view, Chair, that the bill will likely be classified as a Section 75 bill. So as the bill will be an ordinary bill not affecting provinces, and if the bill is classified as a Section 75 bill, the legislative process in the NCOP will be shorter as opposed to a Section 76 process, as there won't be a need for a mandating process. And considering the impugned provisions of both statutes as a very targeted and specialized audience, it is our view that the likelihood of a significant public interest in the bill will be low, and that the public participation process in both houses will most likely not be time consuming. So, considering all of the above, we estimate that the processing of the bill in both houses, including the development and introduction of the bill, will be an approximate period of 9 months. So that, of course, does not take into account constituency and other leave periods. In respect of processing a possible executive bill, as we presented last week, the following factors would favor the development of an executive bill. That would be if the bill requires policy development, if the bill is contentious, or if the bill requires subject matter expertise. So as discussed last week, the only policy development which the department would need is in respect of Section 17 of the MDSM Act. And that such policy can, of course, be shared with our office to be included in a committee bill. The general time frame for the processing of an executive bill in both houses will be similar to the time frame expressed as I expressed earlier in respect of a committee bill, but that would of course be from the stage where a call for public comments is made. The standing rules do provide for options to process legislation on an urgent basis. Although the committee's support staff is better placed or best placed to advise in this regard. Some options may include reducing prescribed periods of time that must lapse before the next step in the process, sitting during constituency periods, etc. Chair, it must be noted that the department may also apply to the Constitutional Court for an extension of the suspensive court order in respect of the O'Brien judgment. But the committee must be aware that the Constitutional Court won't always grant such an order. I'd like to refer the committee to the Constitutional Court judgment of the Speaker of the National Assembly versus New Nation Movement. That's a 2023 judgment. In that case, the Constitutional Court held that extensions should be granted with great caution and not be granted simply as a matter of course or at the last minute. The power to extend the period of suspension of a declaration of invalidity is to be exercised sparingly, and a proper case justifying the need for an extension must be made out, because the effect of suspending the operation of a declaration of invalidity is to preserve law which has been found unconstitutional and void, in order to afford Parliament an opportunity to remedy the defect. Now, the Constitutional Court further held that the extension sought by the applicants in that matter was justifiable, but it must be noted that the court held that granting an extension should not be mistaken for tolerance of Parliament's tardiness or failure to meet deadlines. In conclusion, Chair, our office cannot advise on which route would be the most rational legislative route to follow to ensure that the suspensive court order is complied with. However, we trust and hope that the analysis provided in this opinion enables the committee to make an informed decision. Now, as discussed, there are three options in respect of meeting the Constitutional Court's deadline. So that would be a committee bill. Should the committee opt to proceed with the development of a committee bill, the bill would likely be introduced in the next few months of this year. This time frame will, however, depend on the department's guidance in respect of Section 17 of the MDSM Act, where policy would need to be developed. And we recommend that the committee confirms with the department if such policy has already been developed. So I think that would be crucial if the committee decides to proceed with a committee bill. Then, Chair, there is a possible dual approach. So that would be where the committee decides to proceed with a committee bill, but that would then only be in respect of Section 15 of the MDSM Act and Sections 101 and 102 of the Defence Act, where no policy development is required, because the Constitutional Court has already provided a reading down in respect of those provisions. The department would then be afforded time to develop policy in respect of Section 17 and then to develop an executive bill only in respect of that provision. So there is the dual approach, which is a possibility. The third option for the committee to consider would be an executive bill, So we are of the view that should the department table the bill in February, which now it has indicated that it will introduce a bill possibly at the end of this year, the finalization and processing of that bill and the subsequent assent thereto by the President prior to the suspension of the court's order is possible, especially if the program of the committee considers ways to ensure that the consideration of the bill is prioritized. However, Chair, in our experience, targets set by departments often tend to shift, and an introduction that could possibly come after February 2026 will put the committee under immense pressure. And in that event, the department would have to approach the Constitutional Court for an extension. So, Chair, that is our legal opinion. That is our inputs. I thank you.
Thank you very much, Parliamentary Legal Services, for the input. We would then allow members to advise on the options as put forward. Also allow members to consider the reviewed timelines of the department and their eagerness to be ready in terms of ensuring that we move with the executive bill so that we allow the department to develop, to draft, and to table before us as the portfolio committee and the cabinet and the parliament, and for finalization by the signature of the president as the commander-in-chief and the head of the executive. So I would request members to come in so that we can conclude this particular matter and processes can start. But if honorable members recalls, even the department in our last meeting, they said and committed that they are ready. The only thing was their timelines. Over to you, members.
Chair, I've got my hand up. I see Mr. Hutton too, who shall proceed.
Yes, you can proceed.
Thank you, Chair. And let me thank both the department and also the Parliamentary Legal Services for having given us their particular inputs. Chair, I think it was very useful to get the report from the legal services in terms of their legal opinion, because it helps us to judge what the department has proposed to us. I think we should take note of the fact that the department is keen to present an executive bill, but we should simultaneously also note the fact that the department had allowed 6 months to go to waste. So this leaves us with a question mark on the department's ability and commitment to present this bill and to actually act in terms of even the new timeframes that they've given us. I want to make the following proposals: that we as a committee must keep close tabs on the progress of this bill, as the department is proposing that they want to do it as an executive bill. Therefore, that at this stage, we agree to the department proceeding with it as an executive bill, but we continue to keep close tabs on the time frame that the department has given us. That if there's any instance where the department misses any of the road markers, so to speak, that they've given us in this time frame, that we as a committee immediately intervene. And if we then come to the conclusion that the department is once again tardy and not doing their job, that the committee will immediately take over and proceed with a committee bill. So this is a conditional agreement that I'm proposing, that we accept that the department proceeds with the executive bill option. Furthermore, Chair, I would like to hear from the parliamentary legal advisors whether the proposal from the department for the due date of November, December is in fact one that fits into the parliamentary program, because that brings us towards the end of the year. And if anything goes wrong, if there's a slip up anywhere along the line, we then once again fall back into the situation where this bill will then be brought to Parliament in February of 2026, which is exactly what the parliamentary legal advisors requested us to be careful about, because then the time frame becomes very tight and it places us as a committee in a very difficult position. Lastly, Chair, I think it is very important that we insist from the department and also from ourselves that we will not allow this bill to end up in a situation where we have to request an extension from the Constitutional Court. It is unacceptable, especially in the light of the fact that the department allowed 6 months to lapse, and also in the context of the unpreparedness or the reluctance of the Constitutional Court to grant such extensions. We should not allow that to happen. So I would like to ask the department or anyone who is involved in this process of writing the bill not to sit with the knowledge at the back of their heads that it may be possible to apply for an extension from the Constitutional Court. As a committee, we should make a commitment that we will not allow ourselves to end up in such an unenviable situation. So, Chair, to summarize, I say let's go ahead with the executive bill as long as the department stays within the tight timeframes that they have presented to us today. When they fail to do so, we as a committee must intervene immediately, and one of the remedial actions that we will then have to activate immediately is to proceed with taking over and producing a committee bill. Thank you, Chair.
Thank you very much, Honorable Atten.
Chair, thank you. And also then thank you for the department and for the parliamentary legal team, Ms. van der Merwe and Mr. from Breda, for presenting this to us, the two presentations. Chair, I've got a different opinion as Honorable Nehaus. What we have received in the presentations, firstly, the one from the department is basically deadlines put to themselves, in essence the same as what we saw last week, but just adjusted. But there's no real, nothing coming out of that presentation tells us that there's really an insight into what must be done and the time that it takes. Well, on the parliamentary legal advisor's presentation, we see the detail. How long does it take to do any step in this? So, Chair, I am not comfortable with this. Let's give them a try and see how it works out, and intervene when it doesn't work out the way that we see that was predicted in the presentation here. I'm not comfortable with that. We haven't lost 6 months, we've lost 7 months. And then even then, we haven't got the detail now from the department's presentation on how it will roll out. Well, so, Chair, I'm in favor. If we look at the one option, the total committee approach, then the committee is still bound by the problem with Section 17, where we have to wait for the defence. So, Chair, I'm strongly in favor of the dual approach, where we then do the section 15, section 102, and 102, section 101, 102, and then the department then proceed on their own, obviously also monitored by the committee, also bound to deadlines on section 17 of the MDSM. And I would actually put that as a firm proposal as well. But before I do that, I would just like to perhaps get an indication from the department on this dual approach. Let them comment on the chair if you wish. We've got a clear understanding from the parliamentary legal team what is in it. The only thing that we don't know is the comment of the department on this option. I thank you, Chair.
Honorable Whip, before I go to the department and the parliamentary legal services, over to
Sorry,
you.
Chairperson, I'm in the airport. There will be noise. Sorry about that to the committee. Greetings to everyone in the meeting. Just a short one. I wanted Chairperson to say that I wanted to agree with Honorable Niehaus to say that we take the executive bill. Now that they've got the time frames, they stick to those time frames. As a committee, we look at those time frames. If they do adhere to the time frames that they've given us, I cannot say more because I'm here in the airport. There is some sort of noise. Thank you, Chairperson.
Thank you. You can mute, Whip. All right. Thank you very much, honorable members. Thank you very much. I think I'll give over to the department to answer to points raised by members and give over to the parliamentary legal services before I come with my way forward. Over to you, the department, General Mnisi, and the team, and the SecDef, the legal services of the National Defence Force. You are all more than allowed to comment, including the Deputy Minister, on points raised by members. Thank you. Over to you.
Thank you very much, Chair, and good afternoon. This is Dr. Kamede. Chair, we will request, like we indicated before, that we would like to go the executive route. We have started the work. We members might not have had visibility, but we started drafting quite a while ago. That is why we are able to submit for pre-certification. A dual approach is not preferable because these things go together. We will be able to, and we have capacity to deal with all the amendments that are required, Chair. So we do request that we are allowed, the department is allowed to go the executive route, and members, if we have committed, we are prepared to submit reports as and when the members invite us to submit the reports if they want to monitor the department closely. But we have the capacity, we have done the work, or we have the drafts. So the honorable member who says we didn't give detail, it's because we were presenting what we were asked to present. If we are required to come and present further details on what have been done in terms of drafting, we can do that. Thank you, Chair.
Thank you, SecDef. Any addition from the department before I go to the Parliamentary Legal Services? I see the end of General Ramanzwana. Over to you.
Chairperson, thank you very much. I think the SecDef has stated our positions really. What will be key from our side, which is something that we have already discussed, is to at least, and I think the presenter mentioned it, is to make sure that we do not wait for the committee members to call us. We must always find ourselves in a situation where we always give the committee comfort in terms of the progress of work. And so in short, Chair, I think we have understood what the honorable members have said in terms of the timeframes, but we want to put ourselves in a position where we always are putting the honorable members at ease in as far as the development of in terms of the progress regarding this work. And I would rather end it at that, but to say to the committee, we will rather be the ones that are coming to you from time to time at each and every milestone as per the timelines. Thank you very much.
Thank you very much, General. I'll now give over to the Parliamentary Legal Services to answer on salient points as raised by honorable members. Before I come in, over to you, Parliamentary Legal Services.
Thank you, Chairperson. Chairperson, should the executive bill be introduced in December or November this year, the processing of the bill within the time frame set by the Constitutional Court would be possible. We, of course, propose that the committee keeps monitoring the department's progress in respect of the development of the bill. Chair, even though the bill may be introduced during the festive period, we can still proceed with procurement processes and the publishing and the call for public comments. If we only publish during the festive season, a longer period then can be provided for public comments to come in, because generally, Chair, the public does not respond or consider calls for public comment during the festive period. That's the experience we've had. So we would then propose that a longer period be given to the public to bring their comments if it's published during the festive period. So, Chair, we do believe it's possible. It can be done, but as I said, there should be then close monitoring on the progress of the bill. Thank you, Chair.
No, thank you very much. Both the department and the Parliamentary Legal Services, it gives us comfort if the Parliamentary Legal Services says, based on the deadlines, including the fact that we can go for public comments by December, January, it gives us an opportunity to engage the public on the possible amendment. It will assist. Then I think as a meeting, based on the fact that members feel very strong that we allow you to go the executive bill. But I want to put stringent conditions on the department based on the history of our relationship. As a portfolio committee from the 10th of July this year, we've been a year old in office. When we took over office from the 6th Administration Legacy Report, was the audit queries in the department amounting to 16 billion rand, 8 billion to Project of Easter, 1.2 billion rand to one military hospital, 3.6 billion rand to cost of employees, and the other one goes to miscellaneous. That in the management letter of the Auditor General, including National Treasury, we have not fully answered to those things. And that created a trust deficit between ourselves as a committee and yourself as a department, and we would want you to go back and look at those things and look at how best we can deal with them. But on this one, we agree, let's go the executive route, allow you as a department to develop military law as a responsible official, because military law can only be developed by generals and SecDefs as full-time functionaries of the department related to the military law. So let's allow you to go and do it, but we will put up a serious oversight on your side. The chief of staff has said, we don't have to ask you, you'll come to us and report on every milestone. Let's trust. Don't repeat what you have done to us on the AG and the National Treasury. Let's go and ensure that this work is done. And in that order, the Secretariat will have to write a letter to both the Minister and to the team that is working on this particular project to tell them that this is our agreement from this meeting and these are the timelines, and we expect for every milestone to get a report so that it's properly written in case we end up in Concord or in any court as the portfolio committee. It must not be said that we're in contempt of the court, because I've realized sometimes we're casual in how we relate, and that's not what is very key for us. What is key is to ensure that we promote the rule of law as we are mandated by the Constitution of the Republic to defend the Constitution and all laws and uphold and respect all laws, including all arms of the state. And in this case, the judiciary have expressed itself. We can't go against it. Chapter 9 institutions, AG and Treasury and other institutions, they have expressed themselves on a number of management letters and we defaulted. And I think we need to improve because that's what brings a strain on our relationship as the portfolio committee together with the department. But in you we trust. Please don't disappoint us. Let's go and do this work like we have agreed. Thank you very much, the department. Thank you very much, the Parliamentary Legal Service.
Chairperson.
Honorable Ate.
Sorry, I have the feeling that you are running up. Can I just add something then, if we want to go this route? You see, November, December is a very long period. It's 61 days. I would support that we go this route, but not with the 61 days deadline. That the deadline be for submission to Parliament be fixed at the 15th of November, not at the 31st of December, what November, December actually means. Thank you, Chair.
Okay, thank you. I see there's a hand of Honorable Niels.
Thank you, Chair. I'm partially covered by what the Honorable Hutton said. I agree with him that the deadline should be November, and 15th November sounds good to me. I think what the department must understand is the amount of the deficit of lack of trust that they have created with us as a portfolio committee. Chair, it would have been a no-brainer, and it is the most logical thing to tell the department to go the executive bill route. The reason why we have this discussion today as a second meeting is because of their tardiness, and as you have summarized to us, their history of failure to meet deadlines and to do what is required of them. So under these circumstances, the issues that I've raised and the issues that were raised also by Mr. Hutton were born out of the same problem of a lack of trust and an experience of the department not carrying out its duties. So we're giving the department the benefit of the doubt, and I sincerely hope that they are not going to disappoint us once again. But they must know that, and I'm glad you said that, Chair, that we will monitor them step by step. And they cannot put us in a difficulty. And I repeat once again, We will not allow a situation where we are forced to request an extension from the Constitutional Court. So we're going what is the logical route, but it is a route with risk. Unfortunately, all of us as members of this committee must acknowledge that on the basis of the experiences and disappointments that we had from the department in the past. So, Chair, I leave it also in your capable hands to make sure that this issue will remain on the agenda of our committee and that we will consistently monitor what the department is doing with regards to the production of this bill, so to speak. Thank you, Chair.
Thank you very much. I see there's the end of Honorable Plakis. Over to you, Honorable.
Thank you, Chair. Afternoon, colleagues. No, Chair, I just wanted to come in on the time frames. I think what informed, if I'm correct, the Department and Defense to have an extension till the 31st of December, if I've listened correct, is because they know between that time we will also not be in office. So it will actually give more time for people to give input into the amendments. So I would have leaned to rather try to be more inclusive, Chair, and give more time for comments so that we don't cut off by the 15th of November whilst we are not going to do anything in December. So I would rather also agree that we take it to the 31st of December whilst we ourselves and everybody is not going to work in that time. So the 15th, I agree we want this thing to be implemented speedily, but if there's time, I will agree that we move it to the 31st of December so that we give our people more time to input. We want a participating process, so let us give that time, because it's not going to actually break any time frame, because in any way during that time, most of the time nothing is happening. So I would have liked to go that route, colleagues, just for inclusiveness and making people to get more time to give input. That is it, Chair. I will support that.
No, thank you very much, Honorable Plakis. I see there's the end of Honorable Mutambi.
Chair, I also need to be noted, please.
Okay, Honorable Diale, you're noted.
Okay.
All right.
Thank you, Chair. I want to echo the sentiments of Honorable Plakis on this point. That's number one. Secondly, also, I should think what we are doing is the so-called babysitting, because I believe they are all aware that this court judgment, and if it's contempt, is going to come to the Chief of Defense and the Minister, including because that will be contempt of court if they measure. So what we are trying to do, let's give them space, especially for public comments, for public participation. We are aware if then we're not giving people enough time to comment. If we're inclusive, then I should think we'll align ourselves, knowing, bearing in mind also that we are going on a holiday. This is the we are on recess. Then this is the matter when we come back in the new year, we'll prioritize it. I should think that is fair, because there's no need to put them under severe pressure at the end of the day, then they don't deliver. But I think what they've put in here, they've taken cognizance to say this is within their control and what they will be able to manage. Thank you so much.
Thank you very much, Honorable Mutambi. Honorable Diale.
Thank you, Chair. I think Honorable Niaus and Honorable Harting had this thing on track. The date of the 15th of November, I agree with them that it would assist us as a committee, because what we are doing now, allowing it to be only an executive bill, necessarily put the whole responsibility on them to make sure that as the department that they meet the deadline. The date of the month of the 5th of November and December, it's actually on their own timeline. So I suppose we are not encroaching on their suggested timeline. They had worked out those timeline on the basis that they'll be able to to meet the timelines as they have presented. So I suppose we can, as a monitoring tool, or us as the committee, we can just make sure that we set a deadline to ensure that the work is done. As Honorable Niehaus has indicated, we are not under pressure back around December when we are not even in office, that the work is not done, and we still gave them the deadline of December 31st, and nothing is done when we reopen in January, February. So I suppose let's leave it at the 15th of November as a deadline to ensure that in the interim, after our own recess now, we are continuing to monitor. We've got our legal services, we've got our secretariat of the committee. We ensure that we monitor their progress before the 15th of November. At least by around the 15th of November, we are sure that work is done, everything else is in place. Because we are at this stage risking, considering the history of this department in particular, we are risking allowing them alone to have an executive bill. But monitoring from our side will then be important, hence the importance of setting and agreeing on a date of the 15th of December. That's my proposal. Thank you, Chair.
Thank you very much. Can I get it from the Parliamentary Legal Services? When are we rising as Parliament for December recess? So that we can reconcile the dates between the 15th and December, so that we know when can we table to Parliament before they closes, and our draft goes for printing and it goes for public comments. Parliamentary Legal Services, can you advise?
Yes, thank you, Chairperson. It's approximately the 8th of December when Parliament will rise. Chair, I think there should just be perhaps clarity regarding the proposed dates. I believe the first proposal was in respect of 15th November. That would be for introduction, not for the calling of public comments by Parliament. So I think there should just be some clarity in that regard. Thank you, Chair.
Okay, I think then there's a meeting of the minds. If it's not for public comments, let's leave to that deadline of the 15th of November for introduction. Then we know before the 8th, we would have done publications, we would have started with the public comments, so that when we're on recess and during December and January, the public is allowed for that 2 months to comment on amendments that would be bringing to the Act. I think this is going to also need a serious consultation between the department and the Parliamentary Legal Services to meet and advise each other, including to look at the legal compliance, whether whatever we're bringing as a draft, is it compatible with the spirit of the Constitutional Court order, so that we are also not found wanting by reversals or by further litigation. So I think that consultation and contact will assist us so that we do this. The department, we need to make you aware, failure to live according to the deadlines, you are going to compromising the following people in terms of contempt of the court order. First is the Minister of the Department as the executive head. Secondly is the Chief of the National Defense Force and the Secretary of Defense. And lastly, you are going to compromise me as the chairperson of the Portfolio Committee for having adopted that timelines which you could not live up to. I would be in contempt of the court, and in terms of parliamentary rules and ethics, I can lose my job. The minister also, equally as a public office bearer, she can lose her job. So that's how serious this is. If you don't comply, maybe yourselves, you are covered by labor laws and trade unions, you can survive, but we are not going to survive. Just like it happened with one of our ministers recently, we may also be put under the bus if we're not going to ensure that we meet this deadline and we're not in contempt of the court order. So we wanted to make you aware, because the same members who are agreeing with you today they can refer me or the minister to the ethics committee for misconduct or misleading parliament. Because if this is not going to be complied with, we will be misleading parliament. I've misled parliament on many occasions because of you. On the AG, we agreed from last year, July, that the following things need to be done. On the treasury, cost of employees, we agreed that the following things need to be done. They have not been done. I'm just waiting for any application by any party on me having misled parliament, because we failed as the department and the portfolio committee to live to agreements that we do. And that's why going forward, we are not going to be friendly to each other. We are going to fight, but not fight over money. We will fight over work to ensure that we comply and we complain later. Thank you very much, the department, with those inputs from members. We'll consolidate them from the side of the Secretariat. But I would also request that for me being safe, Secretariat will have to write a letter to the minister and CC specifically the Secretary of Defense, CC the Chief of the National Defense Force, CC both deputy ministers also, so that in case anything wrong happens, then we are vindicated. Thank you very much. We'll then proceed on our own as a portfolio committee to consider the minutes. The department and the parliamentary legal services, you are released. Thank you very much for your presentation and submission. We hope that we will meet the deadline. It's an executive bill. We have agreed. We want the department to ensure that work is done. This is not a civilian department. This is a military department. We expect seriousness and decorum in how we relate to each other. Thank you very much. Thank you. You are released.
Thank you, Chairperson.
Nandipa.
Thank you, Chair.
We can come with the consideration of the minutes before we close the meeting. Over to you.
Okay, thank you, Chair. Afternoon, members. These are minutes of the 16th of July, which was last week. That was the agenda item briefing by the Parliamentary Legal Services on the requested Constitutional Court ruling and briefing by the DOD. That was the attendance register. That is page 2. Page 3. And page 4. Over to you, Chair.
Thank you very much. Can we get a move and a seconder before we go for matters arising?
I move, Chair.
I'll second, Chair.
Thank you very much. Any matters arising from the minutes? In case no matters arising, I will take it that the minutes have been adopted. Honorable Nias?
No, Chair, my hand is down. Anyhow, we did matters arising we dealt with right now in this meeting. So I've got nothing more to say, and I've lowered my hand. Thank you.
Thank you very much. That brings us to the conclusion of the meeting. Thank you very much, Dr. Willems, Dr. van Rensburg. Can we talk privately after the meeting on the letter we need to write to the department so that as the portfolio committee we remain safe in case they do some shenanigans? Thank you very much, honorable members. Thank you very much to the support staff. Thank you very much to the Secretariat. This brings us to the end of the meeting. Go well and do well in your next endeavors. Thank you very much.
Thank you, Chair.